Welcome back, everyone. I hope all of you had a wonderful week. As you know, my name is Leland Walters, and in today's video, we're going to start talking about Article 1 of the United States Constitution. And there's so much involved in Article 1 that I've got to divide it up into two videos because there's just so much that we have to talk about. And I may have to do that with Article 2 as well, talking about the executive branch, but as of right now, we're just going to go with Article 1 in this week's video and next week's video. Next week's video, we're going to talk about the powers of Congress and the restrictions of Congress and on the states. This week, we're just going to talk about the structure, the electing of Congress, and other stuff involved with putting together the legislature and everything. So I want to appreciate all the comments and likes that everyone gave me on last week's video. I'm really pleased to see that so many people are supporting me in this endeavor. So I'm really thrilled about it. Glad to see people are interested in learning what our government is doing wrong and what they're doing right. And I'm just really thankful. If you like my videos, please give me a like on YouTube. Comment. But as I said last time, if you're here to just be negative, if you're here for spirited debate, I'm happy with that. I'm fine with that. I have a friend who's debating me right now on where our rights come from. Hi, Sarah. Love you. And we're having a very interesting debate on it. She and I disagree, but that's fine. I want to hear opposing opinions. What I don't want is trash talk. If you have an opposing opinion, be civil about it. Let's get your opposing opinion. Let's talk about it, and maybe one or the other of us will learn something. Hopefully both of us, because that's what debating is all about, isn't it? So let's get on to Article 1. Let me get my notes straight here. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. And in this first clause, the name and structure of our national legislature has been established. At this point in history, two chambers in a national legislature wasn't all that common. And granting both chambers equality was even more rare. And this is one of the things that made the United States a unique experiment straight from the start. And one of the most important parts of this, the granting of only legislative powers to Congress. Very important to the idea of a limited government that was to be held accountable to the people. That's very important. All right, next clause. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. And here it starts telling you about the House of Representatives. As we all know, members of the House of Representatives are elected every 2 years, and they're directly elected by the people of each state. Now, when it was written, the Constitution did not explicitly grant citizens the inherent right to vote. However, by stating that the individuals who serve in the House of Representatives, the individuals who are qualified to vote for House of Representatives will also be those who are qualified to vote for the largest branch of their state legislature. And the Founding Fathers, in doing that, gave a rather explicit intent that the House of Representatives was to be directly chosen by the people, the citizens. At the time, there was no uniform structure on voting rights. As we all know, we did have an amendment to the Constitution that granted women the right to vote universally nationwide. There were some states who had different voting right qualifications. You had to own property. You had to own a certain amount of property. Mostly only white males could vote. So there was just no uniform structure on it. So in this clause, it pretty much granted citizens the right to vote, but there were still individual state restrictions. The next clause says, no person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. This pretty much, it's cut and dry. In order to serve in the House of Representatives, you got to be at least 25 years old, been an American citizen for at least 7 years, and you have to live in the state in which you represent. There is no federal requirement that prospective members of the House of Representatives live in the individual congressional districts that you represent, because congressional districts are not mentioned at all, but we'll get into more detail on that a little bit later in this video. Representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative. And until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. Alright, that was a mouthful. After considerable debate, the delegates to the Constitutional Convention decided to make population the basis for dividing up seats in the House and tax liability among the states. In order to decide this, they determined that a census must be conducted every 10 years. And this was to determine each state's population and of the United States as a whole. And originally, population was determined by adding the whole number of free people and 3/5 of all other people, in other words, slaves, but excluding Native Americans who were not taxed. And this rule was known as the 3/5 Compromise. And as we know, that's since been removed, but we'll go into detail on this because it's important. The 3/5 Compromise was a compromise between slaveholding states and non-slaveholding states. And I know you're going to say, well, that's North and South. Well, yes and no. At the time, in some parts of the North, slaves were still owned. And it was not prohibited. It was not encouraged, but it was not prohibited. But it was more prevalent in the South. This clause was an advantage and a disadvantage because 3/5 of slaves would count for congressional representation, the advantage part, but the disadvantage, would mean they would count for taxes, which means more taxes would be levied on slaveholding states. That was the thing that prompted the areas of the northern states to prohibit slavery within their borders. The southern states were more agrarian, and therefore they were more wealthy than the northern states. They had the money to throw away, and they were set on a system. And I abhor slavery, and I hope the rest of you abhor slavery. And I'm about to go into this for the Times, a little explanation on it. In 1833, Supreme Court Justice Joseph Story wrote, and I quote, "A matter of compromise and concession, confessedly unequal in its operation, but a necessary sacrifice to that spirit of conciliation which was indispensable to the union of states having a great diversity of interests and physical condition and political institutions." So there you have it. It was necessary at the time in order to keep the United States together. The states that permitted slave ownership had sent delegates to the convention, and these dudes were usually the rich, the well-off, the popular guys, and they threatened to leave and go back home if slaves were not considered, and this would have effectively ended the effort and resulted in the failure of the convention. And as we spoke about in the last video, at the time, the individual states were not going to be able to survive on their own. They had to stick together. So they had to do something in order to facilitate union. The Reapportionment Act of 1929 is something that we need to talk about. It's a law that I have long said was unconstitutional, and I've gotten into debates many times with people over this. It established the constant 435 seats in the House of Representatives to be divided among the states based on their population. And size determination is made based on aggregate national population so long as the size of the House did not exceed one representative for every 30,000 people. That's the constitutionally adhered to part. But at the current ratio, there's one representative for approximately every 700,000 people. That's too many people for one person to have to represent. I think we should double the size of Congress. Well, not Congress, but double the size of the House of Representatives and get rid of lobbyists. But that's an opinion video, and this is factual constitutional video here. Alright, the next clause: when vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. Since members of the House are chosen by the people, whenever a seat becomes vacant for whatever reason, the governor of the state, instead of appointing a temporary replacement, has to call for a special election so the people can fill the vacancy. North Carolina's going through that right now in two districts, the 9th and the 3rd. The 3rd district, Representative Walter Jones passed away, and they're holding a special election now to fill the seat that he vacated by his death. May he rest in peace. And in the 9th District of North Carolina, there was some voter fraud controversy that resulted in a disputed election, and they're holding a special election to fill that vacancy. And both of these seats have been vacant since January the 3rd. Well, the 9th District seat's been vacant since January the 3rd. Walter Jones passed away in February, if I recall, and it's only been a couple of months. But it looks like these seats are not going to be filled until September sometime, and that's a long time for people to not have a representative in Congress. And there needs to be a better system, a more efficient system, and a quicker system to replace members of the House of Representatives. Now, I'm not advocating to bypass the will of the people as the ones who vote for members of the House. I'm not advocating that at all. What I'm saying is calling for a special election should be a process that is quicker and can get done a whole lot more efficiently. Alright, the next clause, the House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. The members of the House of Representatives have the authority to choose a Speaker of the House and officers to other positions that they create. Nothing says that these individuals chosen have to be members of the House, but they have always traditionally chosen from among their membership to the speakership and the floor leaders, as they're known, and the whips, who are the assistant floor leaders. The House also has the power to impeach, which means formal accusation. Now, I'm going to go into this a little bit more detail when we get in with the Senate, but impeachment is nothing but formally indicting somebody on a crime. That's all it is. 2 of our presidents have been impeached, and let's see, we've had several other judges who have been impeached. Some have been removed, some have not. I'm sure you know the 2 presidents who were impeached, Andrew Johnson in 1868 and Bill Clinton in 1998. And both of them were, I won't say acquitted, but they were not found guilty. Johnson was not removed from office by a single vote, and Clinton, he was a little bit more lucky, I'll say that. It's not specified as to how impeachment proceedings are initiated. Until the early 20th century, a member of the House just rose on the floor and proposed impeachment, and then they would assign it to a committee for investigation. Now, the House Judiciary Committee initiates the process, and then they recommend articles of impeachment, which then go to the full House for a vote. If the full House votes on and approves simply one article, then the federal official is impeached. And it's only federal officials that they can do this with. Now, on to the Senate. The Senate is my favorite body of the entire government. It's considered the upper house of Congress, sort of like it's comparable to the House of Lords in the British Parliament, and I'll explain why here shortly. But the Senate, the House, and the House of Representatives is considered the lower house, and you know, that's the. But they're treated the same now. I think there's a reason for certain things, and so let's move on. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. Each state is entitled to choose 2 senators, originally chosen by the state legislature, and that was changed back in 1913, but we'll get to that later, for a term of 6 years. And by these provisions, the Founding Fathers had intended to protect the interests of the states. Just as the House of Representatives was to be the voice of the people, the Senate was to be the voice of the states. According to Chief Justice Salmon P. Chase in the Supreme Court case Texas versus White in 1869, to deny the states their intended role as joint partners in the federal government by abolishing their equality in the Senate would destroy the grounding of the Union, which is why this is so important. During the Constitutional Convention, there was spirited debate about the national legislature. Some of the delegates wanted a single chamber chosen by the people, and opponents argued that this would give the most populated states more power. And that's a concern, an obvious concern. And then some people wanted a single chamber with representation equal among the states. And then the opponents argued that this would mute the voice of the people, which indeed it would. And also the failure of the Articles of Confederation's single chamber legislative body was another factor resulting in what is known as the Great Compromise. This compromise resulted in a bicameral, or two chambers, legislature, both of them equal, one body chosen by the people and the other with equal representation among the states. Very important. Alright, next clause. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into three classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the fourth year, and of the third class at the expiration of the sixth year, so that 1/3 may be chosen every second year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. Well, as we said before, they changed the state legislature part of that, and I'll go into, like I said, I'll go into more detail when we start talking about the amendments to the Constitution. When the first Congress convened in 1789, it was 1789 to 1791, the senators chose their classes by lot, which means they picked it out of a hat or whatever and chose what class that they would be in. But no state has both of their senators in the same class, which is a good thing, because it always leaves one senator who is focused on his duty and not focused on running for election, which I think has caused a lot of problems in this country, but that's another opinion piece. And dividing them into classes ensures that only 1/3 of the body is up for election every 2 years, in contrast to the House. And if a Senate seat became vacant for whatever reason, the state legislature would choose a replacement, and if the legislature was not in session, the state governor had the authority to make a temporary appointment until the legislature reconvened. In recent years, some states have chosen to change this rule and call for a special election to fill senatorial vacancies. An example was when sitting senator from Alaska, Frank Murkowski, was elected governor of Alaska. And that would mean he would have to resign his Senate seat. He did so. And his Senate seat, he didn't resign his Senate seat until the day before he became governor. And the day he became governor, he immediately appointed his daughter, Lisa Murkowski, to take his Senate seat. And that raised a lot of eyebrows. It also caused some uproar. And recently, Lisa Murkowski has kept her Senate seat by election. But she was originally appointed by her father. And this prompted the state legislature of Alaska to change the rule that if there's a vacancy in Alaska's representation in the Senate, the governor can no longer appoint a replacement. He has to call for a special election, just as with the House. As you may expect, Murkowski vetoed that, and the Alaska state legislature overrode it. And I think there are a couple of other states who call for special election if there's a vacancy in the Senate, but I'm not sure off the top of my head which ones they are. The next clause says, No person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state for which he shall be chosen. That's pretty cut and dry. In order to be a senator, you have to be at least 30 years old, a U.S. citizen for 9 years, and you must live in the state in which you represent. Not hard to figure out. Next clause. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. This establishes the only office in the federal government that is both legislative and executive. However, you will notice the deliberate lack of power given this office. The Vice President is merely to preside over day-to-day operations of the Senate and vote only to break a tie. And many individuals who have served as Vice President over the years have well-documented complaints about the office. Things changed about the Vice Presidency in the 20th century, but one memorable complaint for me was, or actually I'll give you two memorable complaints. One was from the first Vice President, John Adams, who said it was the most insignificant office ever the mind of man contrived. There was a little bit more detail to that quote, but that's part of what stood out for me. And Charles Curtis, who was Vice President under Herbert Hoover, said, "I've got only two things to do. Sit up here and listen to you birds talk and keep a watch on the papers to see how the president's health is." And that's it. And, you know, it's rather funny. And it wasn't until Richard Nixon became Vice President under Dwight Eisenhower in the 50s that the Vice President had more duties. Eisenhower appointed Nixon to represent the United States in diplomatic issues, and just gave him a more broad role as Vice President instead of him just being bored to death sitting in the Senate chamber listening to the senators run their mouths. So, and and as you can see here in recent years, Vice President Pence has been representing the United States in some diplomatic issues as well, and vice presidents, I'd say within the last 30 years or so, maybe 40, it could be longer, vice presidents have been attending cabinet meetings. And this is to ensure that should something happen to the president, the vice president is made aware of what's going on, because the vice president will have to jump in, and we'll talk about that a little bit here shortly. The Senate shall choose their officers and also a president pro tempore in the absence of the vice president, or when he shall exercise the office of President of the United States. Just as with the House, the Senate is charged with choosing officers and a president pro tempore, which means temporary president. Also, with the House, these officers are not obligated to be members of the Senate, but they have traditionally done that. In earlier years, the president pro tempore was chosen for each individual session of Congress, which means he served for a period of months when the Senate was in session. And this individual was generally able-bodied and ready to go in case something happened to the president and the office passed to the president pro tempore. Since World War II, however, the president pro tempore is chosen at the first meeting of Congress and serves until another individual is chosen. Also, he has been traditionally the longest serving senator of the majority party and has been an individual generally 70, somebody who's old enough to receive Social Security. Okay, I strongly oppose this. But with this, the President pro tempore also rarely presides over the Senate, choosing to delegate the authority to younger, newer senators so they can learn procedure. And I'm not real big on basing offices on seniority and stuff like that. It's just not my thing. I think you should be chosen because you're the best qualified person, not because you've been there since God was a boy. It's just my personal opinion. Again, you're going to hear a lot of my opinions in this, but I'm basing my opinions on the Constitution. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Alright, back to the impeachment part. The Senate serves as the jury in an impeachment trial. And if the President is on trial, then you have the Chief Justice of the Supreme Court serving as the judge, the presiding officer. This will ensure impartiality because, can you imagine if the Vice President was sitting up there and they were trying the President? You know? Anyway, conviction requires a 2/3 vote, a supermajority. This will ensure that there is no doubt of the individual's guilt. It also serves as a safeguard on the balance of power and ensures that a president can't be removed from office on a whim. So, all of you people calling for Trump's impeachment have to realize, unless you have concrete evidence of his committing a crime, you can't impeach him. Last time I checked, being a pompous ass was not illegal. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, and judgment, and punishment according to law. Should any federal official be convicted in an impeachment trial, they are immediately removed from office and cannot ever be eligible for any other federal office of any kind. And this person shall also be subject to criminal prosecution as a private citizen. The only thing the impeachment does is remove them from office and disqualify them. After that, criminal charges can be filed against this person for the crimes that they committed, and they can be subject to these crimes at any point, unless they are given a pardon, which a lot of people gave Gerald Ford a lot of credit for when he pardoned Richard Nixon after Nixon resigned facing impeachment. He never was impeached, but he was facing it, and Ford caught a lot of slack over that, and I think he suffered for it in the long run. The next clause. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the place of choosing senators. Again, the choosing of the senators has been changed, but let's go into this a little deeper. The states are empowered with how, when, and where federal elections take place. But Congress also has the power to throw their 2 cents in if they want to. As authorized by this particular clause, Congress has set a uniform date for federal elections as the first Tuesday after the first Monday in November. We all know that, of every second year, every even-numbered year. And currently, because there are no other federal regulations, the states have the power to regulate the dates on which other aspects of the election process are held, for example, registration and primaries. And one of the most significant ways that the states regulate the manner of the elections is through electoral districts. Although Congress theoretically has the power to draw these districts for each state, so far they chose not to. They have that power. They have the oversight power. So if your state is struggling with congressional districts, North Carolina, always remember Congress got the power to do it for you, and you won't like it. Now, I'm not cool with gerrymandering anyway. Congress, however, does require the states to conform to a certain group of practices when you're drawing districts. And the law was passed, I believe, in 1842 that required members of the House to be elected by districts. And we'll discuss, like I said, in the area where we discuss the amendments in greater detail, the selection of senators. Congress shall assemble at least once in every year, and such meetings shall be on the first Monday in December, unless they shall by law appoint a different day. Pretty much cut and dry. The Constitution compels Congress to meet at least once a year. They have to do that, regardless. And they established a uniform date on which to do it. And when the first Congress met on March 4, 1789, that date became the date on which the new members of Congress were to be sworn in. So every other year, although a new Congress had been chosen, it didn't take office until the following March, resulting in what's known as a lame duck session. And in the later on in years, the date of being sworn in was changed until January 3rd, and the date of the first meeting of Congress was changed to January 3rd, following the election. Each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a minority number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner and under such penalties as each house may provide. This is one of the most ignored clauses in the Constitution. It states that a majority of members must be present to conduct business. But if you watch C-SPAN, it's very easy to see that most of the time there ain't but a handful of people in that chamber of either one. Quorum is generally assumed to be present unless someone requests a quorum call, a member. And unless the quorum call proves otherwise, nobody really disputes it. Members rarely ask, though, for a quorum call to demonstrate the absence of a quorum. It's typically used as a delaying tactic, which I think is a bunch of crap. But, unless we step in and get them to do what they're supposed to do, they're going to do what they want to do. And there have been a couple of instances where unqualified individuals have been admitted to Congress. Let's see, it was 1818, it was John Henry Eaton who was admitted to the Senate, and he was only 28 years old. But this was an inadvertent thing because Eaton's birth date was unclear at the time. Records have since been found that shown that Eaton in 1818 was 28 years old instead of 30. And also in 1934, Rush Holt was elected to the Senate at age 29, and he agreed to wait until his 30th birthday to be sworn in. And it was at that point that Congress decided to clarify that the age requirement went into effect on the swearing-in date and not on the election date. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. Not really a whole lot to explain here. The Constitution doesn't go into great detail regarding the rules and such, and as a result of that, it leaves this open to each house. I think that's a bit of a mistake, but our founding fathers were geniuses. Who are we to question them? But I think there needs to be a little bit of clarification to these, to certain areas in the Constitution. Each house shall keep a journal of its proceedings and from time to time publish the same, excepting such parts as may in their judgment require secrecy. And the yeas and nays of the members of either house on any question shall at the desire of 1/5 of those present be entered on the journal. Each house of Congress is required to keep a record of their business and publish it, except for what in their judgment requires secrecy. National security crap. I mean, they can say anything requires national security. You know, the decisions of the House, and not words that were spoken during debates and speeches, are recorded. And if 1/5 of a quorum requests it, the individual votes of the members are recorded and published as well. You can find this information on the House and Senate websites, and you can also purchase books with the information, and I highly suggest everyone do so. It may seem boring, but it's important to know what our representatives are doing. Very important. Neither house during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. This clause is also pretty self-explanatory. Often one house or the other will hold what's called pro forma sessions every 3 days to simply fulfill the constitutional requirement and not to conduct business. Another pile of crap. Anyway, the senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases except treason, felony, and breach of the peace, be privileged from arrest during their attendance of the session of their respective house and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place. Okay. Members of Congress determine how much they're paid for their services. Bad freaking idea. This has raised a lot of questions for decades, but no action has been taken on it because the American public are officially dumbed down on the powers that we do have. Okay. Members of Congress also share certain privileges with similar privileges with members of the British Parliament. They can't be arrested during their attendance of session. They can't be arrested in going to and coming from a session of Congress. And they also cannot be sued for slander occurring during a debate on the floor of either house or a speech during a congressional session. You can't use that during criminal prosecution. The only exceptions are treason, felony, or breach of peace for the arresting of members of Congress. Gravel versus United States in 1972 affirmed the latter part of this about slander. Mike Gravel published over 4,000 pages of the Pentagon Papers in the Congressional Record, a action which might have otherwise been considered a criminal offense. But under this clause, they can't do a thing to him. And I think it was a good thing that he did that, to be honest. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office. This is what's famously known as the ineligibility clause. It just means that you can't be a member of more than one branch of the government at the same time. In other words, you can't be sitting in Congress and serve as Secretary of State or be on the Supreme Court or whatever. And obviously you can't do it unless if the pay has been increased for a particular office. Basically, and I'll give you a recent example. This is important because it ensures the total independence of the three government branches. And the recent example I want to talk about is Joe Biden in 2009. Biden not only was running for vice president on the ticket with Obama, but he also was running for re-election for his Delaware Senate seat. He won both elections. As you may know, Biden became vice president under Obama. but he also won re-election to his Senate seat. Well, since Congress is sworn in before the president and vice president, Biden took office as a senator on January 3rd, 2009. And he did so with the intent of the Delaware governor being allowed to choose his replacement once he had to resign to become vice president. He resigned as vice president on January 18th, I believe, and then 2 days later was sworn in as vice president. And I'm sorry, that's a practice, and in my opinion needs to stop. You know, if you're running for one office, you shouldn't be allowed to run for another one. It's just ridiculous in my opinion. And that will conclude this video. I'll get my notes ready for the second part. That was Article 1, Sections 1 through 7. The next one will cover Sections 8 through 10, which will talk about powers of Congress, restrictions on Congress, and restrictions on the states. And we will get into that next Sunday. If you have any questions, comments, please feel free to leave them. And if you like this video, please like it. And I will happily see you good people next Sunday. Peace to all.